How to talk about accessories or features when it comes to fights over what arms are protected, what objects are protected by the Second Amendment. This is a very important point that I think sometimes gets messed up by certain people in the Second Amendment community. So I'm going to do this video right here and right now to make sure that whenever you're confronted with a question about whether or not something is an arm under the text of the Second Amendment, you get it right to make you the smartest person in the room and to win for our Constitution. Let's break it down when we come back. Hey folks, I'm Mark Smith, host of the 4 Box of Done, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so this is an important topic, and I want to make sure you all get this right. Whether you're doing your legal briefs, whether you're writing your legal opinions, your memos, your articles, you're just posting stuff on social media, writing op-eds, whatever it is, I want to make sure you make this critical point if you're ever in a situation where you're talking about how to defend or really attack gun control laws that try to ban or regulate so-called features, objects, items, anything like that associated with firearms. And what do I mean by this? As you probably have seen, there are attempts by the anti-gun movement in America to ban or regulate or tax, whatever you want to say, things like forced reset triggers, magazines that hold more than 10 rounds, maybe even optics at some point. But whatever it is, and of course we also know things like suppressors. So with all that said, I want to make sure that you argue this correctly, no matter which item the anti-gunners are objecting to in your jurisdiction or in your paper or whatever it is that you're confronting. Because it's very simple to argue this, but a lot of people kind of get confused or they miss the point or they get led astray by anti-gun arguments, and we don't want you to ever be duped by them. Specifically, what you start to see by the anti-gun movement is they use two words that are signals to us that they're playing games. They will start to use the word accessories, or they might try to use a kind of an old foreign word called accoutrements. Now, when you see words like accessories to a firearm or accoutrements to a firearms, or accoutrements at the time of the founding, do not let these words scare you away because none of these things are going to be a problem for you to address. The most important thing to do is to not buy into the idea that these are somehow to be assessed in a vacuum. In other words, whether or not one of these items, accessories, objects, accoutrements, whatever you want to call these things, these don't have to be an arm in and of themselves. And you don't have to address it that way. What you need to do simply is this, is to point out that a firearm that uses any one of these objects is an arm, and a ban, let's say, on suppressors is a ban on firearms that fire suppressed rounds. A ban on magazines that hold more than 10 rounds is the equivalent of a ban on an entire category of firearms that are capable of firing more than 10 rounds without having to be manually reloaded, and so on and so on. So whenever you're dealing with any of these sort of object items, whether it be suppressors, forced reset triggers, any of these kinds of things, your point is simply that don't address these in isolation. Take these things, imagine in your head, attaching them to a firearm, and then asking yourself, what gives? Is this a ban or a tax or a regulation on a firearm with this sort of a feature? Because if it is, you're dealing with an arms case. And if you're dealing with an arms regulation, you're dealing with a gun control regulation. And if it's an arms regulation, it is implicating the text of the Second Amendment, which reads, of course, the right of the people to keep and bear arms shall not be infringed. And again, just to jog your memory, if you think about it, there's really only three things at the textual level that has to be satisfied before the burden shifts to the government, for the government to have to show through history that their modern day gun control law is justified. And that is, number one, the right of the people. So you got to deal with the people, meaning you're an American citizen or a green card holder, someone who's lawfully in the United States as part of the people. The people have a right to keep and bear. So you have the right to keep, which means to possess, the right to bear, which means to carry. Arms, which is a specific kind of item. So whenever what happens is the anti-gun movement in America is trying to say things like magazines, forced reset triggers, suppressors, whatever it is, these are accoutrements or these are accessories. These are not essential or necessary for the gun to fire. But if you think about it, there's all sorts of things associated with a firearm that's not needed for the gun to go bang, bang, right? But nevertheless, it's still protected. Why? Because you know why. Under the Bruin case, and this is a very important sentence, I want you all to write it down and to remember, it's very important if you're involved with these debates over what is an arm as a matter of text. You need to write down the critical language from Nysurpa versus Bruin, the Supreme Court case in 2022. And again, the key language in Nysurpa versus Bruin that you need to remember is the one that says that instruments that facilitate armed self-defense are arms under the text of the Second Amendment. Instruments means more than just like bang, bang, gun, gun, right? An instrument is an object. It's an item. The Supreme Court could have used the word weapon, a weapon that facilitates armed self-defense, but they didn't use the word weapon. They used the word instrument. Why? Because an instrument is an object that is broader than, let's say, the weapon itself, if you think about it. And facilitate, something can be helpful to you, but not necessary. Just take a very basic example. A baseball batting glove, okay? You don't need gloves to hit a baseball. You don't need gloves to hit a golf ball, for example. But many baseball players and golfers will wear types of gloves to protect their hands from getting blisters, let's say. So those batting gloves or golf gloves facilitate hitting a baseball, or they facilitate hitting a golf ball. Are they necessary? No, they're not necessary. But those batting gloves or those golfer gloves are helpful to the activity. So too, if you look at Bruin, items, or in this case, instruments, according to the Supreme Court word, instruments that facilitate armed self-defense are helpful for armed self-defense. It's not necessary, and a magazine that holds more than 10 rounds may or may not be necessary, but whatever you want to say, a magazine that holds more than 10 rounds, it certainly helps with armed self-defense because it gives you more rounds if you need them. A scope may not be necessary to shoot a gun, but it helps you shoot a gun and facilitates armed self-defense because it makes it easier to shoot the bad guy if you have to shoot the bad guy in a self-defense situation, right? So too a suppressor. You don't need a suppressor to shoot a firearm, but it helps you shoot the firearm safely because you can, you can tap off a round, right? You can shoot the round, right? But guess what? It's not going to hurt your ears and your hearing as badly, if at all, if it's firing with suppressed rounds, right? So to me, this is another example of an item or an instrument that facilitates armed self-defense, but is not needed. So whenever you're dealing with these attacks, which you sometimes see games getting played by anti-gun scholars, anti-gun politicians, and they make comments like, this is just an item that's unnecessary. You don't need it to fire a gun. You don't need it to protect yourself. But remember, take that item in your mind, connect it to the gun, and then talk about the gun with the item being the arm, and don't just talk about the item in a vacuum, because a bullet in a vacuum, if I'm just looking at a bullet, a cartridge, it doesn't really do much for me without the gun. So again, but it's pretty clear to me that ammunition is an instrument, right? A round is an instrument. It's an item. It's an object that certainly facilitates armed self-defense, because if you have that ammunition, that cartridge, that bullet, that round, whatever you want to call it, and you put it in the gun, it helps the gun go bang, bang, and do its job in protecting you in the case of the need for armed self-defense. And again, never forget that language from Bruin. It's extremely helpful. So now, once you understand that you take whatever item the anti-gunners are labeling, an accessory, or an unnecessary item, or a feature, or an accoutrement, whatever they're labeling as that, you in your mind abstractly connect it to the gun and discuss the firearm with that feature attached to it. And you talk about the firearm with the feature attached to it, and that's how you talk about it. And that is an arm. It could be, again, a gun with a suppressor is an arm that's capable of firing suppressed rounds. An arm with an FRT is a firearm capable of firing more rapidly if needed. A firearm with a magazine that holds more than 10 rounds, again, is a firearm able to fire more than 10 rounds without needing to be reloaded. You see how you do this at the textual level? And again, once you've now won at the textual level, the burden shifts, as you know, meaning that once you've established that the text of the Second Amendment is being implicated by the modern day gun regulation, the burden shifts to the government, and the law, the gun control law, is presumed to be unconstitutional, and the burden shifts to the government. And the government has to use history to justify the modern day gun control legislation or the regulation. And that history, of course, we've talked about before, is a very detailed set of long-standing and representative types of historical analog laws. Okay. Now, once you shift to that history, the only point I want to make, and then I'll wrap up here, is this. When you shift to an arms ban situation, a ban on suppressors, a ban on FRTs, a ban on magazines that hold more 10 rounds, whatever it is, a ban on scopes, a ban on red dots, whatever it might be that the anti-gunners are trying to get away with. Once the burden shifts to the government, the in common use test applies. And remember how this works historically, as Heller said. The only conceptual historical laws that were well representative and long-standing and well established at the time of the founding that could conceivably justify a ban on a type of arm is if those arms are dangerous and unusual. And that is, listen carefully, folks, it's very important. That dangerous and unusual test is a historical-based test. And why is it important that that dangerous and unusual test is a historical-based test? Is because the burden of proof to satisfy the dangerous and unusual test is on the government and not on the Second Amendment rights claimant. Which means that if you support the Second Amendment as a rights claimant, you have no duty, as a matter of law, to prove that the arms with suppressors, that arms with hold more than 10 rounds, whatever you want to call these, are in common use. Because the burden at the historical level is on the government, which means that the government lawyers have the burden of proof to prove that these guns capable of firing suppressed fire, guns capable of firing more than 10 rounds, guns with FRTs in them, the government bears the burden to show that these arms are not in common use. And or they have to prove that these guns are dangerous and unusual. And the reality is the government cannot prove that what I've just identified are dangerous and unusual because the reality on the ground is these kinds of arms with these items attached, which means you assess them as an arm in total, these arms are obviously in common use because there's like over 3.5 million suppressors in America. There's tens of millions of magazines that hold more than 10 rounds in America, and so on and so on. So the government is simply not going to be able to establish its burden that these are not in common use, and therefore they're not going to be able to show that these arms are dangerous and unusual because they cannot show they're unusual because they can't show they're not in common use. So never forget that the dangerous and unusual and the in common use discussion, the gestalt of them, the dialogue about them, the proof of them This all occurs after the burden has shifted to the government to show a historical set of laws and a historical precedent and all that at the historical level. And never forget footnote number 11 in Bruin. Footnote number 11 in Bruin says what? Footnote number 11 in Bruin, the Supreme Court said in 2022, if the historical record is ambiguous or confusing or unclear, the tie goes, if you will, to the Second Amendment rights claimant. The tie goes to the unqualified command of the text of the Second Amendment. So again, when you're dealing with these arms ban cases with suppressors and magazines and so on, the burden is on the government at the historical level, and they simply cannot overcome that burden. And the reason why it's at the burden is on the government is because it all occurs at the historical level after the burden has shifted from the text to the government. And the presumption is that the modern day gun control law, the modern day gun ban that the anti-gunners are trying to uphold, the presumption is it's unconstitutional, and the burden is on the government to overcome that. And when you're dealing with arms ban cases, they're simply not going to be able to do that when you're dealing with any of the sorts of things that we've been talking about kind of in the modern era, the sorts of items that, get discussed and bandied about in terms of banning guns. Okay? So anyway, I hope this is sort of a helpful reminder about how to deal with these accoutrements and these features and these sorts of games that the anti-gunners like to play, and one way to just overall lump them together and attack back and show why we are right and these laws violate the Second Amendment. So there you have it, folks. Hope you learned a little bit something today about how to deal with these kinds of issues. Make sure you follow me on X at @4boxofdiner. Don't forget to subscribe both to YouTube and Rumble. I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.